Ty Lee appears in person. Attorney Michael Tobin with the Public Defender's Office making a special appearance. Ms. Lee has advised me that she has retained counsel. She has retained Attorney Jessica Nicholson. However, Ms. Nicholson is not present at this time.
Do you expect that she's going to be here this afternoon?
Yeah, I don't know if she was made aware that I was in court, and I just found out, but she should be on the way.
Okay. Would you like us to skip your case for a little bit and provide some time for her to get here?
For the record, my name is pronounced T.
Lee. Okay, thank you.
I'm going to give Ms. Lee a copy of the criminal complaint so that she may review it.
I think that's fine.
Provide to her attorney.
So unfortunately, we're going to have to return you back to the lockup, but we'll take your case in a little bit.
All right, thank
She's
you.
not here. I can stand up with you for the hearing.
Thank you.
Oh.
Wisconsin versus Christopher Terrell, misdemeanor bail jumping.
Robert Hurley appears for the state of Wisconsin.
Mr. Terrell, I understand you have a private attorney, but I won't just include it today. Your Honor, Mr. Terrell appears in person and by Attorney Michael Tobin. I note a special appearance to reserve any jurisdictional objections and issues.
Okay, and is the address on Jennifer Street correct?
Yeah.
Okay. And are you going to be getting him a lawyer, Mr.
Your Honor, I understand that he has retained an attorney, just is not available for today's.
My understanding from members of the audience, I guess, is that Jessa Nicholson or Jessa Lutz has been his attorney in connection with the other pending case, and it's anticipated that she'll represent him in this matter. It's also my understanding that she doesn't intend to be here for this court proceeding today. We'd be happy to adjourn the case or do something that give an opportunity for her to be here, but it sounds like that she's intending that you go forward with either Mr. Tobin or representing yourself for today. Okay, very good. Thank you. I do need to make sure that you are aware of your rights to an attorney. You can apply at the Public Defender's Office. If you meet their guidelines, they'll give you a lawyer. You're certainly free to hire a lawyer on your own, like Ms. Nicholson, or you can choose to represent yourself. Do you understand all those options? Oh. And Mr. Hurley, what's the state's position regarding bail?
State without objection to signature bond on the condition that Mr. Terrell follow all Wisconsin administrative rules, administrative code rules, excuse me.
Mr. Tobin?
Your Honor, I've never heard the entire administrative. I understand there can be good faith issues, actually having worked in a capacity of promulgating administrative rules and having seen individuals wearing robes and on benches even find that those rules are invalid and the agency legal counsel being called into play. So I would ask that that be amended to state statutes, which are easier to have that interpretation.
Well, there is a statutory condition of bail in every case that somebody not commit a criminal offense.
I think that would cover what Mr. Hurley's getting at.
Well, the other issue I have when I review this complaint is I do make a practice of determining whether there's probable cause. Maybe I'm missing something, but I'm not sure that I see probable cause in this complaint. The complaint alleges that he violated a condition of bail, specifically to follow all Wisconsin administrative code rules. And then I think what's alleged is that he engaged in videotaping in the assembly gallery in violation of the rules of the assembly. Aren't the assembly rules different than the administrative code?
As Attorney Tobin said, the administrative code is deep and far wide-ranging. There is no doubt about that. Whether the assembly rules are contained within the Wisconsin administrative codes, I do not know.
Your Honor, I'm going to adopt the court's suggestion in the form of a request that it be dismissed. This present complaint be dismissed without prejudice for lack of probable cause. There is not the references to a state statute which talks about not committing a crime. Obviously, administrative code itself would not be a crime without connecting the dots, and I don't see that in the narrative part of the complaint or reference to an actual section in the administrative code or administrative register. And I appreciate the court pointing out that deficiency in the complaint.
Did you want to add anything more, Mr. Lee?
No.
I don't pretend to be series of administrative regulations that are promulgated pursuant to a process, and they have the effect of the rule of law. Due to the delegation from the legislature to the administrative agency, I think they're distinguishable in fairly significant ways from the assembly rules, which govern conducts of individuals in the gallery and in the areas that fall within the jurisdiction of that house, as well as the conduct of their members. I think they're two different things, and I don't think a violation of the assembly rules or the rules of the gallery on its face constitutes a violation of the administrative code. That's important, not because he's actually charged with violating the administrative code, but because he's been charged in a criminal complaint for violating a specific condition of bail to be abided by the Wisconsin administrative code. I don't think this criminal complaint adequately sets out a violation of the administrative code. There isn't a citation to some provision of the administrative code that would be violated by the conduct that's alleged in this complaint. What it alleges is that he is on bail, there's a condition of bail to obey the administrative code, and it alleges that he violated a rule of the assembly. And I think there's to use the connect the dots analogy, I think there's a failure to connect the dots in at least one respect in the course of the complaint. That avoids the whole issue of making a determination as to whether a condition of bail like this is the one that is appropriate in these circumstances. So I'm going to grant the defendant's motion to dismiss. I'll dismiss this complaint that is by definition without prejudice, meaning that the state is free to refile it if they can produce a criminal complaint that more accurately or adequately sets forth probable cause to do that. Is there anything else we need to do with respect to Mr. Terrell's case here this afternoon, Mr. Rowe?
No, Your Honor. Is there a date in the underlying procedure that you remind Mr. Terrell?
Oh, that's a good question.
December 2nd.
Oh my God, he's out.
State of Wisconsin versus TV.
She's staying in jail.
Ms. Lee appears in person by Attorney Michael Tobin. I would note a special appearance to reserve any jurisdictional issues, Your Honor.
Well, first question is first. Do you know whether she qualifies for a public defender, or is it also anticipated that she'd be represented by Ms. Nicholson?
The latter, Your Honor.
I'm making reference to some things that occurred during an earlier hearing involving the case of the state of Wisconsin versus Christopher Terrell. In that case, we were informed that Ms. Nicholson represents Mr. Terrell in an underlying case, and that it was anticipated that she'd be representing Mr. Terrell in this case. Ms. Lee, I think you're in the same position, is that right? Okay, and knowing that Ms. Nicholson is not here today, and knowing that I would grant you an adjournment if you wanted to have this hearing with her present, do you still want to go forward today, either representing yourself or Mr. Tobin? Okay. The other thing I need to inform you of, though it seems a little redundant at this point, is that you do have some rights with respect to being represented by counsel. You have the right to apply at the public defender's office if you meet their income guidelines, they'll get you a lawyer. You have the right to hire or retain counsel of your choosing, as you've described, and you have the right to represent yourself. Do you understand all that? Okay. Normally I'd ask to turn to bail, though we had an earlier hearing involving Mr. Terrell where we had some discussion about the sufficiency of the criminal complaint. But you're not sure that I see a meaningful difference between this complaint and the Terrell complaint, but we should probably make at least a complete record on that point in this case because it is called separately.
Your Honor, and again with the defense's gratitude for your close reading of Mr. Terrell's complaint, I would point out the similarity that the allegation is that Ms. Lee violated a condition of bond in a previous case by intentionally failing to comply with the administrative code rules. However, in the body of the complaint, it appears that at most there's an allegation she was given a slip of paper purporting to set forth some internal rules of the one of the branches of the legislature without any allegation that they are in part that they are made part of the administrative code, let alone that Ms. Lee would have been informed that they would have been part of the administrative code, let alone that she would have been at the time that she took whatever action or failure to act or omission, that she would have been intentionally in violation of any administrative code rules. So therefore, I would ask that this complaint be dismissed and as precedent, state v. Terrell, 11 CF 2. Call the court.
I seem to recall the case.
It's a 2011 case.
Though it's from about the lowest court in the land. Mr. Burley, do you want to be heard?
I was not struck by lightning when they connected the formal connection between the administrative code and assembly rules in the last 5 minutes, so I have nothing to add.
The long case for Mr. Terrell's. The criminal complaint here alleges a misdemeanor bail jumping violation. It specifically alleges that Ms. Lee violated the conditions of bail that were set that required her to refrain from, I should say it the other way, that required her to follow all Wisconsin administrative code rules. The body of the complaint alleges that she was in the assembly gallery at the state capitol, that she was in some fashion involved in video recording or engaging in some behavior within the chamber that is in violation of the rules of the assembly. It doesn't allege, either by reference to statute, administrative code, or otherwise, that a violation of the assembly rules is somehow a violation of the administrative code. My limited knowledge of these things tells me that there is a difference between the administrative code, which is promulgated by various administrative agencies with